Welcome to the Stratford IP Strategy Academy. In this session, we will discuss what role intellectual property plays in mergers and acquisitions, and ways that you can make sure your IP portfolio is optimized to always be showcase ready. Let's get started. Not that long ago in mergers and acquisitions, IP was considered to be an afterthought and didn't carry much weight. Increasingly often, however, IP began taking a more significant and upfront role in M&A, especially in the patent-heavy tech world. In fact, the value in terms of many deals can be heavily influenced by the value and state of the IP in the target company's portfolio. Whether you are the acquirer or the seller, IP can no longer be an afterthought. From the acquirer's perspective, due diligence is important to understand the value of the IP being acquired, whether it has been properly safeguarded to ensure it is not infringing or at risk of being infringed, and that everything is in order for a smooth transition. From a seller's perspective, you should know if and how you use open source software, if your IP is currently being licensed, and if you acquired IP from another source, and that the chain of ownership is intact. It is especially important to know the worth of your assets so that you are in good position to bargain with the acquirer. M&A terms are negotiable, so entering negotiations with information and proof to back up your claims and valuation will let you know if the acquirer is undervaluing your IP. Google famously offered their search algorithm to Yahoo for $5 billion in 1998, which Yahoo declined for being too expensive. Google understood their value, and now they're worth $1 trillion. Preparation is imperative from both sides in any M&A scenario. However, for the remainder of the session, we will focus on the steps you can take to prepare for an M&A as an IP owner. Every battle is won before it's ever fought. What Sun Tzu meant by this sentiment is that preparation is everything. You cannot expect to win a fight if you are ill-prepared. This is especially applicable in the world of mergers and acquisitions when it comes to IP. Be proactive in managing your resources and treat due diligence as your battle prep. If you are not ready when approached by an acquiring company, the outcome may already be decided and you risk losing the deal. It would not be the first time that disorganized IP derailed progressive talks about potential mergers or acquisitions. The steps you take to ensure a successful M&A begins with how you manage your IP portfolio day to day and should begin long before a merger or acquisition is on your horizon. If you are in a position to enter into an M&A, you can expect the acquiring company to do their due diligence, so it is prudent that your portfolio is prepared for the scrutiny. Anticipate a number of questions, sometimes hundreds of them, from the acquiring firm around the historical and active processes, the portfolio activity, the quality, and the organization. A good guiding principle when it comes to how you manage your IP portfolio is to expect someone to walk in off the street and offer to buy your portfolio today. Typically, negotiations move at a rapid pace, especially in a multiple bid scenario, and an unorganized portfolio will diminish your capability to command an appropriate market price and close the deal effectively. Closing an M&A deal can be a tedious and arduous process, as is, and often requires involving technical and legal experts in due diligence who will dissect all aspects of your IP. Ensuring you are taking the appropriate steps now to ensure your portfolio is properly cataloged will save you from additional stress and put you in a better position to mitigate any scenarios that may cause the acquirer to abandon the deal. The goal is to keep your IP in a state where it is always due diligence ready. In order to be considered prepared for the scrutiny of a due diligence review, you should have the following documents fully filled out and available. Consider how you might organize this information for ease of access both internally and externally for investors or acquirers. You should have these documents for each product and IP type, regardless of whether it is active, licensed, or closed. You want a summary of your IP holdings, including by country, status, product, IP type, number of families, active versus closed IP, and sorted by year. In addition, you want a detailed portfolio for each piece of IP, including a complete filing history containing the spec, figures, application data, prosecution responses, as well as any relevant numbers and dates, such as application or issued numbers, filing dates, priority dates, issue dates, expiry dates. You want the title, the inventors, the country in which it was filed, and the docket number. You will need the assignments and declarations from each inventor for each filing, preferably organized by family. You will need details of any incentive program for the inventors, including the historical payouts. You want copies of all R&D or third-party contracts in which IP is referenced and/or licensed. You should have the current and historical IP costs and the projected IP costs for the next 12 months. You should have all the employee contracts, specifically the PIIAs or other items which indicates that inventions are to be solely owned by the company. You should have documents that detail your IP processes, including how ideas are captured, adjudicated, drafted, and filed. And finally, you should have all historical publications, such as a thesis, dissertation, trade journal publication, by all your named inventors in the company, including those from prior to the inventor joining the company. Many due diligence examinations follow a predictable sequence. You can prepare yourself by considering your answers to the following questions. How are you safeguarding your confidential information? Who works on the IP and who else has access? Are there NDAs in place for all the people with access? Is the claim to IP ownership clear and indisputable? Meaning, are all the assignments and chain of title clean and in the name of the company? Which IP is considered the most valuable and why? Were any government grants utilized to develop the IP? And if so, does the government have any rights to it, such as those under Bayh-Dole? Has the company been party to any lawsuit, infringement, or other legal communication related to the IP? What tools or other resources have been used in the management and protection of the IP? Has the IP been submitted to any third parties, such as standard bodies? Is it being used appropriately, and will the relationship continue if ownership is transferred? Is there any use of open source software, and is it being used properly under the terms of the license, and are all modifications recorded? If there are any items on this list that you do not presently have the answers for, chances are your portfolio requires some strategic management to get it in order and due diligence ready. It may seem like a tedious and laborious task if you're tackling this for the first time, but the time investment now will pay dividends to you in the event of an M&A. There are firms and programs that you can tap into to assist with cleaning up your IP. There are a lot of moving pieces during M&A discussions. No matter what side of these negotiations you fall on, IP should be one of the top considerations on your list of influential factors, and proper due diligence should be expected from both sides. If you are the selling party, preparing your IP portfolio should begin well in advance of any potential acquisitions, so that you are aware of the state and value of your IP and won't be derailed by any potential surprises. Your IP portfolio is only valuable if it's properly cataloged in a way that showcases its worth, both internally and externally. Proper documentation and diligence will give you the evidence of market value and will ensure your IP commands the proper price.